Okay, thank you. Thank you for that feedback. Um, I guess the question I'd have for that is, okay, first of all, we're trying to lay down the minimums that we'd be asking for from them. But now the other issue we would have with making it a CBA is because there are a lot of data workers, a lot. I'm sure even Joanne and F and DLA do not have the full list. So saying that you'd need to be part of a union for this agreement or these terms to apply to you would be a bit, there are a lot of people who'd be locked out because as it stands, I believe DLA has around 800 members, but that's not the full number of people, rather data workers that are out there. Secondly, it will go back to the union aspect. DLA is an association. A CBA needs a union. So that's another barrier or another challenge that we'd have approaching it that way. But I do understand what you're saying. And I think we also know that whatever we're trying to achieve won't be achieved right now or immediately. We are just trying to, push the limit slowly and slowly.
Just before you go, I would like you to look at the genesis of how the Doctors' Union was formed. Just go through the genesis before during the tenure of Dr. Lunga. Just look at that era, and then to really inform that approach. They were an association. And when they went to court, based on the same things that they were agitating for, the court said our hands are tied, especially from the labor court. So they had no alternative, but they had to switch. So it's something, even for the people who are seated here, it's something that you really need to critically reflect within, because I know it will be a give and take from an individual point of view. It's difficult. And it should be from a point of view that no employer would want you to be unionized. No way. For them, they want their profits. For you, they want you to sweat it out. But it's something, for me, just reflect through it. I'm not a lawyer, but I'm speaking from somebody who worked in programs for journalists and the dangers that have been happening. And just maybe a good practice. There are so many associations that have been formed as a regard. So another low-hanging fruit has been, if there is an existing maybe union that almost speaks the same language, can you be affiliates? It's another low-hanging fruit as an alternative. Because at the end of the day, you'll be achieving what you are fighting for. But I'm just throwing in the carrots.
I think Joanne can say more about the union/association thing.
I'm not going to speak about the union/association thing. I'm just going to add to sort of defend why we came up with a model contract. Most of the time, I'm going to refer back to what the conversation we are continuing to have is, as DLA, we don't want to speak by every time complaining. We just want to come up with solutions. So one of the issues that we have been facing is the issue of contracts, where you're given a 35-pager and you're given 5 minutes supposed to sign the 35-pager. Or at times it's 2 lines where you're told, this is the project that you're supposed to work on and blah, 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 and all those things. So even for us as DLA, like the level we are at now, we have learned through the journey. We did not know what our protections are. We did not know. Basically, we knew anything. We did not know anything about labor laws, and it crept into to the point that some of our human rights were also exploited without our knowledge. So the reason as to why we came up with the document, I don't know legal. It's called legalese, but the CBA and all, I don't know the difference. But the reason as to why we came up with this contract is to address that issue of everybody having issues with the contract. So we decided to use a simple language where each and every data worker can understand whether they know law or they don't know law. Two, we decided for it like to have a length where even if you're given like 30 minutes, it's something you can just run through and you understand all the nitty-gritties and everything. Three, it has all your social benefits, or all your pay, everything that you're entitled to is indicated there. So that is just why we thought of coming up with a model contract, and that why we choose to call it a contract and not a CBA, because it was part of the conversations that we are mainly having and we find as the solution. So we wanted it to be part of the code of conduct, because the code of conduct mainly is going to address all those things. That is why you've seen like the flow of the conversation has been like it's generic, from the conversation you're having about mental health, conversations you're having about pay, which we just want it like to open conversations in everything that matters in the AI work and in this data work that we are doing.
And just to pick up from where you left, but also joining my brother there in terms of the issues that he has raised, I totally agree that it's a journey and it has started the conversations, and it's quite ideal. Like this is where, this is what decent work looks like for data labelers, and these are the minimums that you get from, that we need in terms of having or ensuring decent work. But then how do you also bring it to light? I know that this is just a journey, and just to adding to the thoughts that my brother was asking about CBA, because it would have been, a CBA is a collective bargaining agreement made by trade unions, between trade unions and employers. So it would have been very ideal in terms of having your own, like, this is our proposition, and then the employers, and then you negotiate, and then you agree on the terms, then it becomes binding for everyone. The challenge would be in terms of bringing it to life is, as a worker, you know that these are the bare minimums, and me belonging to the data labelers associations, these are the minimums that I know that I should have. Then your power at that particular time of bargaining, counter proposal for the contract that you've been given, at what level will the employer agree to your counter agreement? Because probably the NDs, the contracts that you've been signing have probably very little that have been listed in terms of the issues that you're raising. So I think next steps should be, how about what are the opportunities in bringing this to life? But also, this brings also like an opportunity in terms of the policy and the legal framework space, because there have been conversations around regulating the digital economy in Kenya, and there's been like, I don't want to call them clueless, but they've been like weird propositions in terms of how to regulate the digital economy without necessarily looking at the rights of workers in the digital economy. Could it be an opportunity for you also engaging as stakeholders in this digital economy in terms of saying these are the minimums, and probably they would see themselves into law when they are not there? The other opportunity could be sectoral bargaining in terms of ensuring that you have a sector agreement that shows that these are the, if you are investing in this sector, then these are the minimums that a company needs to comply with in ensuring the protection of these workers. So there are different dynamics in how to go about that. But also it would be important to take note of what has been raised in terms of trade unionism, and why it's very important in terms of looking at what are the opportunities, looking at the future, because then you'll always be lacking locus in terms of discussing or intervening, where you even have the mandate, but then the law does not necessarily mandate you to bring to life some of these recommendations or these models that are coming out. So I think those are the things that maybe in the future, for future considerations, that you should also be having. And lastly, on the employer issue, it's very tricky because capital always has a way of thinking outside the box. So if we have a certain definition which is narrow, then there will be definitely in the future probably another way of an employer saying, you know what, according to this definition, how can we not make ourselves liable? And then we are now excluded from the agreement or from the term employer as defined in the model law. And then they'll come back and tell you, you know what, you guys are the ones that proposed these definitions. So I feel like it's still a very dicey conversation, and I think even staying away instead of even attempting to define, could be a little safer than defining it. So I think it's because if you say contracting parties, sometimes the multinationals, and there are so many layers in the supply chain, so how will they also be held accountable in terms of ensuring some of these rights are lived by the data labelers? Thank you.
Too much. Before I start, is there anybody that wants to make a comment? No, okay. I'll just build upon, not to monopolize the conversation too much, but the supply chain is something that's worth considering. And where does the power lie within that supply chain? That's something that we're talking about mapping, right? And I think that might look a little bit different for our BPO workers than it looks for the platforms. But at the end of the day, it seems like there's just a couple of apex tech firms that are really the clients of these companies, and they are outsourcing their work across the board. And so maybe the contracting party that you want to engage is maybe that apex firm, which is a model that we've talked about, right? And maybe they can then ensure that through their supply chain, these standards are met. And so they're the party that you want to engage. Another thing too, which is really useful to draw upon our laws and our constitution. And it was very interesting to hear about how worker is defined in the constitution. I often think, though, that these companies, they're really looking for global solutions. And of course, we are Kenyans, and from our perspective, it's like, this is the be-all and end-all. But maybe there's other forms of policy that we can rely on that you could refer to. I was just thinking of like European due diligence, human rights, business law, that kind of stuff. A lot of these companies are European or North American, and now they have to adhere to those policies. And so that doesn't change at all the constitution of what you've done, which is really good, and I should have started there. But I guess because it's good work, we just jumped right inside. But it's excellent work. But maybe we could also refer to those policies, those European policies. And those standards might be even higher than what we're thinking of now. And it doesn't matter where the worker is, whether they're here in Kenya or they're in Malaysia or they're in Philippines. Those standards are all the same.
Yeah, thank you, Njeri. I think that has opened the floor, and all the different opinions and insights are very, very eye-opening, to say the least. But I would also like to say this is a great step towards where we're aiming for, and for that I applaud the team. I would also like to remind all the stakeholders in this room that I would hesitate to ask for us to be reaching for the goodwill of some of the platforms and private companies that contract the work out to BPOs. And this is not to push back against what she has just said. I'm just thinking that sometimes when we play it safe, and that's because that's the word in my head right now, we give room to people who are looking to push the envelope even further. So some of the data labelers here in this room talked about having done this work from 7 years ago, right? And these issues are not new. The issues are just coming to surface now because someone has highlighted the issue. And so some private companies, some platforms removed themselves from the responsibility when the first documentary came out about the summer project. They removed themselves and said, when we contracted this work out to summer, we paid them money to pay the data labelers well. So we are out of the question. So now the worker is left with who then am I supposed to look for accountability? Is it the BPO who is already looking also to milk them and make the most of the profits?